The next thing is the trial story principle. And this is something that we've learned now that's developed over the last 15 years. Each juror imposes their own model of what the case is about during the primacy portion of the trial. They form their own model of the case. Each juror also formed their own opinion and their own model of the lawyer, of what this lawyer is about. Is this a lawyer I can trust? Is this a lawyer who's trying to persuade me right off the bat? Is this a lawyer who's using, oh yeah, I recognize that. It's one of those lawyer tricks. I see it on TV. They're forming opinions of the lawyer during the primacy portion of the trial. And the opinion of the lawyer is part of their trial story. The lawyer part of the trial story includes their opinions or their biases about trial lawyers. And there are biases about trial lawyers. The case I tried recently involved a trial lawyer as a defendant. So we did a very extensive juror questionnaire about lawyers. And after my second challenge for cause, the judge said to me, Mr. Nations, if you're going to challenge all of these people who don't like lawyers, we'll never get a panel. We'll never put 12 people in a box. And he was right. So I had to make a decision to take the 12 people that I thought were most honest about their opinions and didn't have a hidden agenda. In the way you make presentations, you have to maintain trustworthiness, competence, and dynamism. Those are the three things that make jurors like lawyers. The next thing is the steps that they go through in the formation of a trial story. First is orientation. The second is conflict. The third is emergence. Then the fourth is reinforcement. Now let's talk about those steps and how they come about creating their trial story during the primacy portion of the trial. The trial story is so extremely important, and the trial story is each juror's own model of what the case is about. It's important because from the time they form their trial story, which is during the primacy portion of the trial, once they form their trial story, they will filter all of the evidence that they receive from that point through their trial story. That is to say, they will try to seek information that supports their view, or they may reject information that opposes their view. So it's extremely important that they adopt the trial story that you want them to adopt that is most beneficial to your case. Now, the primacy portion of the trial, which I mentioned, primacy is the voir dire examination, the opening statement, and the first witness. So with that in mind, you have to think very carefully. Who do I want to be the first witness in this case? Who do I have that can best convey our trial story so that the jurors will adopt our trial story in the case? Because the jurors have options. They can form their own model of what this case is about. They can adopt the plaintiff's model of what the case is about, or they can adopt the defendant's model of what the case is about. In an ideal world, you want them to adopt your model of what the trial story is about. You want them to adopt your trial story. Now, it's been my experience, hard learned, that you have a far greater chance of having a jury adopt your model of the trial story if you have one. So the whole idea is to take the principles we're talking about today and form your trial story. Once you get them to adopt the trial story, you argue, you direct, you cross, and you persuade, and you ask your questions in terms, in the language of your trial story about what the case is about. You tap into the model of the leaders of the jury. Most importantly, you want to make sure that the people who are going to be your jury advocates in the jury room are people who have bought into your trial story. So as you're looking for people on the juror questionnaire, if you know what your trial story is, you can look for people who you think are going to be the advocates in the jury room, who are going to be arguing to bring other people over to their side of the case. And you're looking especially on juror questionnaires for the people who are going to be the leaders who are most likely to tap into your trial story. because the trial story is extremely important because jurors use it to perceive, store, and most importantly, to retrieve the information during jury deliberations. And the juror advocates will use their trial story to persuade the people who are the followers, or the people who are the mediators, or the people who are just, okay, let's move one way or the other, but let's all get together and get out of here. And you have those. So you have to be very careful that you're on the same page with your leaders of the jury. The next thing you use the trial story, you fill in the evidentiary details with your trial story. Bias fills the evidentiary gaps during deliberation. So you want to make sure you have a trial story that fills in all the evidentiary gaps that you need the jury to know to make the right decision in the jury deliberations. And the storytelling elicits a strong availability bias by spotlighting evidence in a memorable form. We all love storytelling. We're raised with storytelling. Your trial story should be the foundation of the storytelling that you're going to do in the opening, in the summation, and in the eliciting from the witnesses during the direct examination. Because storytelling elicits a very strong availability bias by spotlighting the evidence in a form that they will remember.